de darmos início ao evento, gostaríamos de reforçar o seguinte disclaimer. As manifestações expressas por integrantes dos quadros da Fundação Getúlio Vargas e por convidados que participam dos eventos e transmissões online representam exclusivamente as opiniões dos seus autores e não refletem, necessariamente, a posição institucional da FGV. Após este vídeo de aviso, solicitamos a autorização para o uso da imagem e da voz dos palestrantes mediante manifestações de concordância, tais como um aceno de cabeça ou outro gesto de aprovação. Agradecemos sua participação e desejamos um excelente evento.
Okay, good morning, everybody, and good afternoon and evening for those who are following from afar. My name is Nicolas Zingales, and I will be the host for this webinar. I'm a professor at FGV Law School, where I coordinate the Center for E-commerce Studies, and I'm also a researcher at the Center for Technology and Society. And I would like to start prefacing this webinar, which is going to be on interoperability and transparency remedies for open mobile ecosystems. Also acknowledging that the Center for Technology and Society receives supports with no strings attached from a number of donors, including some companies that would be potentially in the scope of the regulation that we are discussing today, such as Meta and Google, as well as foundations who advocate for more regulation in this space, such as the Open Society Foundation and the Ford Foundation. As you might have heard, the Brazilian Congress is debating these days draft legislation that would introduce preventative ex-ante obligations for certain market players designated as having systemic impact on digital markets. And this will be following basically in the footsteps of other jurisdictions around the world. To discuss how this connects to that broader global debate and the importance of this shift, I'm joined here by a stellar group of experts who will help us to understand the promises and challenges of this type of framework, taking as a case study today the context of mobile ecosystems. So I'll start by introducing our speakers who will deserve a much longer introduction, but each of them has several features in their curriculum that make them particularly well placed to discuss the issue with us today. But I'll be brief in the interest of time. So first of all, we'll have an opening keynote by Professor Fiona Scott Morton, who is the Theodore Nierenberg Professor of Economics in the School of Management at Yale University and an adjunct professor at the law school. Among other things, she founded and directs the Truman Arnold Project at Yale, which is a vehicle to provide more competition policy programming to Yale students and the wider competition community. And she was also involved in the Stigler Committee on Digital Platforms, which was one of the reports that from the beginning of this discussion suggested some concrete ideas for regulation, and the author of a paper that we are going to discuss today, which is about equitable interoperability as a tool for digital market regulation. So followed by Professor Fiona's keynote introduction, we will also move to another jurisdiction that is the European Union, where we have with us Alba Ribera Martinez, who is a lecturer in competition law at the University of Villanueva and a visiting professor at the Brussels Study Center. And of course, she's a prolific author on digital markets and the founder of Binary Agora, and also a regular contributor of the Voters Competition blog. So she's going to tell us a little bit about the situation in a European context. Then we will move to our participant from Japan. We have with us Mr. Kazuhiko Fujikawa, who is an associate professor at Keio University and a specialist on competition law. We will hear about the Online Mobile Software Competition Act that has been recently introduced there. Then finally, we will come back to Brazil to hear a bit about the ongoing cases and the current framework that is being introduced for digital market regulation. We'll hear it from Victor Fernandez, who is, well, both a professor at the Institute of Public Law in Brasilia, but also a commissioner at the Competition Authority, CADE, where he wrote some of the most insightful opinions on digital markets. And he also wrote a book on digital platform and ecosystems before it was cool, as some people would say. So congratulations, and thanks to all the speakers for being with us. I understand that Mr. Kazuhiko is joining us a bit late. He's not currently with us yet, but will certainly. Oh, yeah, there he is. Good morning. Well, actually, good evening in your case. So I'll start by just giving some context, and then I'll leave the word to Fiona for the opening keynote. I think that it would be useful to just provide a little bit of the situation that has made us arrive at this proposal in Brazil. And let me see if I can share the slides here. Yes, there it is. So I'm part of a center that is doing a lot of monitoring on digital markets, and we were involved since the beginning of this discussion, which was in 2022, more or less. I mean, that's when the first proposal for an ex-ante regulation of digital markets was made in the Brazilian Senate. And here the idea was we recognize that there are some companies that have a massive influence in the economy and that can leverage their position in some of the key channels for commerce and extend their market dominance into other segments of the economy. And here, basically, the first proposal was trying to use the text or some of the insights of the Digital Markets Act that was introduced in the European context. And it replicated some of the same dynamics, however, with some issues of lost in translation, such as, for instance, the threshold for companies that would be designated as gatekeepers was extremely low, was 70 million reais, which was equivalent to 15 million euros, as opposed to the 75 billion that were used as a threshold in the European Union, 75 in global turnover, or 7.5 over 3 years to qualify as gatekeeper. So this would lead to a lot of designated companies. And another feature was that there would be the telecom authority in charge as basically a regulator, as enforcer of this framework. And one positive aspect of this bill was that it would introduce a tax to allow the authority to cope with the enforcement expenditures, and would impose a 2% tax on gatekeepers. However, it would impose it horizontally to all gatekeepers, not depending on the level of expenditures that each of them generates. which was what the original idea in the Digital Services Act of the European Union suggested. Okay, so then there was, following that proposal, a lot of debates, criticism, constructive criticism over how we can advance for a more robust framework. Commissioner Victor was one of the leading voices in this, but also there was some activity in CADE, the competition authority. There was a study of digital markets in the BRICS, where it was advocated that more effective tools are needed for digital markets. And in 2024, CADE, for the first time in a public consultation that was opened by the Minister of Finance over a possible ex-ante framework, CADE recognized that, yes, such framework was needed, and it wanted to be the authority in charge for this framework. And then the report was issued in October 2024 by the Minister of Finance and included a number of suggestions over how to deal with power in digital markets. Basically, it would allow the authority, would give power to the authority to designate some company as having systemic relevance for digital markets and impose some special obligations to these companies. There's a number of suggestions that were made, but you see basically the ones that were actually incorporated into the bill. I would say there's only 3. So this about the designation of platform systemic relevance, the imposition of special obligation, and the use of a specialized CASE units. The other proposals are currently being considered and could be part of the implementation of this bill. But basically, this is what we have now. We had advocated in November 2024 that market investigations could be a tool to tackle more effectively digital markets. And this was based on the proposal's idea that a first obligation that could be imposed is a transparency obligation that gatekeepers would have to offer on a regular basis. And then you can go deeper to the extent that you identify further problems that are not just about transparency. And this is not reflected in the current framework. So we don't have transparency as a baseline obligation, but it's one of the obligations that can be imposed. And this is why also we included it in the title today as one of the important issues. So, and to conclude, I just wanted to briefly show you what this ex-ante bill says. Basically, what are the key points? First of all, the bill has clear objectives that refine what was previously in the first text, in the first bill that was introduced, that had a lot of different objectives. Here we have 3 key objectives. Differently from the Digital Markets Act, we don't have fairness specifically recognized as an objective. So I think this is something that can be debated to what extent it can be used as an interpretative tool for digital markets regulation. There is a specific superintendent for digital markets, and this superintendent not only helps with the enforcement by recommending to CADE, what companies to designate and how to apply obligations, but also is accompanied by a secretary for economic monitoring that would help the enforcement of digital markets and also potentially promote impact assessment over the obligations that are going to be imposed. The bill is much more nuanced on the criteria that are used, both quantitative and qualitative, following recommendations made by CADE in the public consultation. And as I mentioned, there is no baseline transparency obligation. The only standard obligation that applies once a company is designated is that it must have a local office with contact information so that basically you can initiate a dialogue with these companies. And this perhaps links to the whole Elon Musk saga with X in Brazil that at some point left the Brazilian market, so didn't have an office here. But the bill does not include a specific exemption or justification for the conducts. However, it says that it will consider a number of factors in imposing these special obligations. And what is interesting is, compared to other bills, the obligation applied to the whole economic group, but then the authority can decide to narrow it down. So the designation is to an economic group, but the obligation can be a bit narrower, depending on what the authority thinks the problems are. And they must take into account the improvement of the main functionalities of the ecosystems. And finally, the point that is useful also for academia, civil society, anybody that is interested in these matters, is that there is a process of public participation through submissions and public hearings before any designation or before any imposition of special obligations. So this creates a whole ecosystem interested in digital markets regulation, and I hope that we will be able to participate effectively in that. We have a letter of support that is coming out. We'll put it out for signatures tomorrow. Anybody interested could scan the QR code here and get in touch if their organization or individuals want to sign this letter. And now I then want to close my introduction, returning to the topic that we use as an overarching framework for this webinar, which is interoperability. We already discussed about interoperability in a previous seminar, and we want to continue this conversation because we recognize that interoperability will be one of the key interventions in digital markets. And we have discussed already in the last webinar that some of us have been doing work on this, but today we are particularly fortunate to have with us one of the authors of this paper on equitable interoperability that was for us an inspiration to understand how this type of remedy can guide the enforcement in digital markets. And so with that said, with that introduction, I would then give the word to Professor Fiona to enlighten us with that, with an introduction over interoperability and how she sees the situation from the US standpoint.
Great. Thank you so much, Nicolo. It's a great pleasure to be here. I have slides, and I actually put my article in the slides, not realizing that Nicolo was going to advertise for me. So I apologize for the duplication. But here, here's the basic justification. And I think Nicolo has said a lot of these things, but let me just emphasize why we have a problem and why we need this kind of principle. So the problem is that the entrenched gatekeeper platforms are here. They have market power, they have network effects, they're extremely difficult to dislodge. So if you want to increase competition and innovation, it's very difficult to do that with just an ordinary antitrust case where you say, oh, look, Google's now a monopolist in search. How do we fix that? We see both in Europe and the United States that it's very difficult to fix that. So an alternative is to free up entry and competition on the platform rather than trying to dislodge the platform itself. Now, why does that help? It creates an incentive to invest because there's legal certainty that the business user can't be excluded from the platform, so they are willing to put money into building a business. And they are going to get competitive or fair returns to the complements. The business users are complements, and they're going to invest and innovate, and they want to know that they're going to get some money back. So both they're going to be able to have a return and not have all the money taken by the platform, and they can't be excluded. They can't build something valuable and then have it cut off by the platform because it's too threatening to the platform. And of course, being discriminated against is another version of that. The other interesting thing about this approach is that when you allow complements on a platform to come in, have users, and innovate, they can innovate any way they want, and those innovations often are going to threaten the platform itself. And the platform, if it has control, would cut them off, but if there's regulation, it cannot, and that is going to create a long run increase in competition because those complements can grow and morph into competing platforms. Okay, so this is exactly the what Nicolo just described, and I'll just say that I'm going to talk about mobile operating systems right now, but these ideas can be applied to a number of digital platforms, the ones that are at issue globally. So what is the challenge in the mobile ecosystem in particular? Well, it's a critical market. It's really the way every business now is interacting with its own consumers. If I want to launch a new electric car, I need an app. If Google or Apple said, we refuse to carry your app, it would be very difficult for me to run my electric car business. So it's just the gateway to users, and it's the gateway to GDP. There's only two of them. So we have a duopoly and consumer single home. These are expensive devices, and so consumers typically have one. They're a little bit differentiated. You're locked in, so you've got your handset, and you're going to consume the things. You're going to consume goods and services through that handset according to the rules of that handset. So this makes that handset then suddenly an extremely important gateway to pretty much everything you do, the information you see, and the products and services you buy. On top of that, then, innovation by business users who would like to use that channel is going to be stymied or directed or reduced because they are not free to do what they want on the handset because of the rules of the gatekeeper. And this is likely to be high value stuff because the gatekeeper is only interested in a narrow direction and business users are interested in broad directions. And I'll come back to that. Having said that this is a big problem, it's also the case that a lot of the solutions are much easier than you might imagine. So first of all, the gatekeeper has chosen and defined and designed the interface that is the App Store that sits on top of the operating system and the apps that sit in the App Store. That was all constructed by the gatekeeper. It's not like the regulator has to do technological innovation or do coding or invent something. Moreover, the gatekeepers did not keep all of that intellectual property proprietary and secret. They opened the interface to developers. They published software development kits. They sought developers to come. They really want indirect network effects. So they picked what this interface is and opened it. And light touch regulation can protect competition by saying, look, you open the interface, now you can't use it to discriminate against your rivals or exclude. Light touch regulation can protect innovation. The interface can't be used to exploit through high fees, exploit developers or consumers through high fees, and thereby reduce the incentive to innovate. And it can't direct innovation. So these regulations are not very invasive by the standards of most government regulations. How would this work on Apple? Let's think about that for a minute. Right now we have an app store. We have, as I said, a duopoly operating system, user single home. We've got a monopoly app store on Apple. It sells content that's expensive, 30% commission fee. It's of mediocre quality. Searching doesn't work very well. Searching is corrupted by ads. There's a fair amount of dangerous content on there. And importantly, it's one size fits all. It's got more than 1 million apps on it. It's giant. It's got irrelevant apps. It's got junk apps. It's got so many things I don't want to buy that it's like walking into a physical store with all the things you don't want. And it's just a very unpleasant user experience. So let's think about what could happen. Well, we've got regulation. The DMA allows entry, and this could be a great experiment. Spoiler alert, we don't actually get to see the great experiment quite yet because the DMA is not fully enforced. So we're not at the end of the journey. But why is this a difficult path to walk down? It's because it requires imagination. And App Store innovation hasn't happened because there's a monopoly App Store. So you might say to yourself, why is Fiona talking about App Store innovation? I can't even imagine what that is. You're right, because you've never seen it. Okay. And that makes it difficult to protect. It's hard to get votes from people to say, protect this innovation that I can't describe to you because it's innovation. So it hasn't happened yet. Apple focuses us all on price. Apple wants the conversation to be about price. And basically the narrative is, who cares what the gaming and dating businesses pay? That they're scammy, they're bad for you. If they raise price, that's kind of good because we don't want people spending time on that. And if we open up our interface, scammy web stores like porn are going to come in and your privacy will be at risk and so on. This, however, is, first of all, I think there's a number of reasons why we don't have to go that direction and we can protect people. But the welfare is not going to come from lower prices in games, although that is perfectly valid as a source of welfare. And I put it as the first bullet point here. The commission level will go down when there's competition, and we like lower prices. But very importantly, there are going to be new kinds of app stores that are complements to another business, that do curation differently, that handle payments differently, that do technology differently. And I'll get to examples of each of those. And it's very important also to understand that valuable innovation in app stores, if Apple opens up their interface and there are multiple app stores and they do great things, Apple can monetize that through the handset and through other Apple products and services. So there's no problem for the business model of Apple in benefiting itself from this innovation that others are likely to put forward. Why would Apple, however, not want to do that? Because app stores become middleware. And middleware is profoundly threatening to an operating system, because once I can log into my app store and it does everything for me, I can actually be flexible across operating systems, because as long as the operating system supports my app store, I log into my app store and there are all my social apps and my commerce apps and my travel apps and so on. And I don't really care what operating system I'm on. And if you're Apple or Google, that's extremely threatening because, of course, once we can all move across mobile operating systems, there might be entry and competition in that space. So let me tell you a little bit about the business model innovation. You can imagine games at lower prices. You'll recall that Microsoft owns King Games, Candy Crush, and the like. And that means they're paying 30% to Apple. Well, I'm sure if they could open an app store that they ran themselves and keep that 30%, they would be very attracted to that. You can imagine an app store as a complement to an existing business. I have a fancy American Express credit card, and I can imagine American Express loving to put an app store for rich people on the iPhone, which has in it all kinds of apps that are designed for traveling and rich people, and that share, that market and share data, and everything gets paid by the American Express card. There are other kinds of business models that require more control over the App Store. In Estonia, more than half the people who voted in the last election voted digitally. But they have to vote on a desktop because there is no app for voting that is sufficiently secure. The problem is that the App Store has to not keep track of what you're doing to be secure for voting. And very reasonably, existing app stores do keep track of what you're doing. So that's fine, but the Estonian government would like to have its own app store it could use to allow for mobile voting. That's an example of something that would generate a lot of course, surplus for society that we can't do right now. And then there's new technology like the metaverse that Epic Games would like to put forward. On curation, you can imagine a children's app store that had very restricted, very safe content. You would need to remove the regular store. The Google Play would have to divide into what's actually the operating system, which would stay on the headset, and the storefront itself, which would have to come off so that children couldn't get there. You could imagine a store that was an environmental, like a green store, that you could not get into as a developer unless you had a low carbon footprint. So you'd pay a little fee to evaluate your business, you'd be allowed in, and then people like me could make the green store their primary store and try to use the scooter or the bank or the food delivery that was in the green store. I personally would love just a tasteful store. I want something that is smaller, that's curated to my tastes and needs and serves a niche audience, and you can imagine just an unlimited number of those. And that would be really, really pleasant because then I could find things. I would listen to the marketing in that store because I would know that it was designed for me. Here you really want a universal search function. So when you go onto your handset and you go to the little bubble that lets you search for stuff, when you put in an app, it shows you which store has the app. That would be extremely helpful. Okay, privacy and security. Apple wants to worry about that a lot. I think it's a bit of a red herring. I mean, the gatekeeper would continue to review apps as it always has because the apps have to work on the handset. So Apple has to review apps. Google has to review apps. Of course, you need to regulate that function to ensure it's not used to replace existing barriers. We don't want a rival to face $1 trillion fee for reviewing its app. So the fee probably has to be based on something approximating cost, and it can't be discriminatory. I also think it's very reasonable to have a licensing scheme for rival app stores. We don't want criminals or Russian hackers or whatever opening up app stores, and so it's very reasonable to have a background check to ensure they're following proper protocols for handling security and privacy, and they have a corporate governance and so on. All of that's fine. And again, that function probably needs to be regulated to ensure it's not used to block competitors. And the rules for what's required have to be perfectly transparent because it's really a safety check. And you could authorize a third party to administer it. You could say Accenture or KPMG or somebody can carry out these checks. And then, as was recently found in the UK litigation, privacy and security will become a dimension of competition, and users can decide whether they like an app store based on that basis, as well as what else it does for them. Many jurisdictions are working on this problem at the same time. So we have our private litigation in the United States on Epic. We have our government litigation. Actually, I should have put US v. Apple there too, but that's much farther down the road, so less relevant for today. The UK litigation I just mentioned, class is moving forward in the UK. We have the Digital Markets Act in the EU, and we have other bills that I know less about in Asia, Japan, and South Korea, and of course, KAJE, which we just heard about. How do we achieve interoperability? In the US, we've seen that antitrust is a difficult route to go. So essentially, Apple won Epic v. Apple. It was only that they refused, the judge made them do one little thing, which was allow developers to tell users that they could save money by going outside. And because Apple essentially refused to do that, they ended up in much more trouble with the court than they otherwise would have. So now developers may steer users with a link to buy on the developer's own site for a zero fee. And that's in place right now. And that happened really because Epic did not follow the instructions of the court, the original instructions of the court. In Epic v. Google, we have a strong judicial remedy requiring app stores. This is now challenged by a new agreement that Google and Epic have come to. And there's going to be hearing about that, and we'll see whether the initial remedy is changed. But the court requires third-party app stores for bids, payments for placements, and requires a catalog so that users can see which app is being distributed through which store. Regulation, however, is also a difficult road, especially when the gatekeepers are powerful and there's a war in Ukraine. Okay, that's kind of a problem for Europe at the moment. And so there are a couple of issues. One, Apple is saying that they're going to charge a commission for content distributed through rival app stores in Europe, which seems not appropriate. There's also technical barriers that both Apple and Google are putting in place for rival app stores, which are unnecessary. Obviously, we know how to make these work. So I would say when you're thinking about your own legislation, you want to take all of these lessons from other jurisdictions into account to try to guard against those things going wrong in Brazil. So why is a regulator a great idea? I think, as I said at the beginning, it really increases business certainty. If you know you can get on to the app, into the app store or onto the operating system with your own app store, that allows you to invest. It allows you to invest because you can't be discriminated against, you can't be kicked off. So this opens paths for all kinds of interesting local innovation that responds to the people's needs in Brazil, which I promise you are not being addressed by Apple, because there's a bunch of people in Cupertino and they're developing needs for what they think people should want. And I think there's a lot of, therefore, low-hanging fruit on innovation. And then developing public interest expertise, developing long-run relationships with platforms so you understand what they can and cannot do. And then an ability to study emerging issues like the CMA does with the market studies and the market investigations is really great. We see, of course, AI coming along, and the first thing we're going to want to do is study that. So I'll just quickly say we have one good experiment in China where there's App Store competition, but it's a very different environment, so it's an imperfect experiment. But lots of innovation in handsets, innovation in super apps, as I mentioned before. This is middleware and lowers barriers to switching, and that's very important. And there are many app stores operating in China. Now, one problem is a lot of them got together and colluded to make the commission be 50%. So that's a little bit problematic as a benchmark. But let me just show you, I asked ChatGPT to go find a bunch of these because there are so many dozens of them. So I'm not standing behind all of this information, but at least it seems like we've got hardware-focused app stores, monetization-focused app stores, niche content-driven app stores, security, privacy-driven app stores, state app stores, aggregator app stores. So just a lot of choice, and this is the kind of business model differentiation I think we need. Okay, I will close by promoting my book, which is free and available for download at the URL that you see right there. It's a PDF. And it has in it the article that Nicolo and I mentioned, but also some others covering different aspects of regulation of digital platforms, mostly through the lens of the DMA, but trying to bring economics into the conversation to illuminate what's a universal problem and therefore a universal solution, no matter what jurisdiction you're in. So please do take advantage of that. And then I think this is a moment of great promise. App stores are an important channel for competition and innovation. They're a huge gateway to economic activity now. And the regulatory solutions are surprisingly simple. So I encourage Brazil to learn from international experience as well as economic learning. And thanks again for the invitation. I look forward to the discussion.
Perfect. Thank you very much for this insightful introduction. I will keep the question after our presentations, our set of presentations. I just want to mention we have a Slido on YouTube, so everybody can go and input their questions, and they will be asked. It can be in an anonymous form as well. We look forward to your questions. And I want to stress how important is also what you mentioned about innovation, the fact that interoperability allows also to cater for more local solution of the local ecosystem. This is something also we put forward in the letter of support, and it's particularly important, this controversy that there is nowadays over regulation killing innovation. So thank you for that. Transitioning to our next speaker, I also want to clarify what really particularly attracted us in this concept of equitable interoperability is that it makes clear that it is not just a technical issue of interconnection, right? There's a lot of ways in which you can frustrate interoperability by applying discriminatory rules, or even by having opaque, non-transparent systems that you can then implement. You can use justifications to apply in non-even fashion the rules, for instance, of the App Store or the mobile ecosystem. And so in that respect, I think that it would be particularly interesting to hear the experience of the European Commission in the Digital Markets Act. There is a case that discusses very clearly that tension between a more technical and a more expanded notion of interoperability. So with that, I would leave the floor to Alba. Professor Alba, thank you very much. You have the floor.
Thank you, Nicolo. I'm also sharing my slides. I have prepared a couple of slides, which makes it a bit easier to understand this particular topic. And before starting the presentation, I also wanted to thank you, Nicolo, for the invitation to participate around this topic of interoperability. And in particular, in my previous work, I have also focused on vertical interoperability mandates, also as a means to try to foster this role that Professor Scott Morton was talking about complementers in digital ecosystems, both through, as you'll see, EU competition law and also through ex-ante regulation. So translating all of this topic and this issue onto mobile ecosystems, I also and wanted to ask, how can really complementers innovate on the sidelines of really an incumbents ecosystem by, for instance, catering to these complementary features and functionalities that really interact with the ecosystem holders operating system. So if we turn our attention to EU competition law for a minute, when we talk about interoperability, we meet different scenarios that have merited also distinct interventions on the side of competition authorities. So for instance, a competition authority cannot simply interpret that all denials of vertical interoperability are equally harmful for a competitor. On one side, the outright denial of interoperability, for example, Apple's refusal to provide access to its NFC functionality, must be analyzed under the essential facilities doctrine, to the extent that it also entails the elimination of competition and namely of an indispensable input that the competitor cannot forego to operate its business model. And on the other side, we place also within these theories of harm that competition authorities can put forward degradations of interoperability that cause different times and different types of harms, due also to their lower intensity and also to their degree, as well as the many forms that they adopt, such as, for instance, the imposition of unfair terms to access the interoperable features to an operating system, or the competitors tying to particular features which do not quite provide equivalent access to that competitor. So, assuming these two theories of harm revolving around both the denial of interoperability or the degradation of interoperability, competition authorities also face an additional obstacle, that of imposing remedies. So when those restrictions of competition take place contractually, as in the ecosystem holder imposes such and such restriction within a contract, competition authorities may possess enough knowledge to eliminate those restrictions on paper. However, as Professor Scott Morton was also commenting on, and later on Nicolo, interoperability restrictions seldom make their appearance contractually. Instead, they take place technically and de facto, so as a matter of fact. For instance, a particular complementar's service or app may not really work as smoothly when interoperating with the operating system as the ecosystem holders' proprietary apps do. From the perspective, therefore, of EU competition law, the behavioral remedies that must go into these sets of cases require considering, I would say, two tenets of interoperability. So the degree of technical integration that a competition authority can feasibly ask from an undertaking vis-a-vis its competitors, and also the objective or the necessity and proportionality of the restrictions that an incumbent may introduce in terms of making feasible that particular vertical interoperability mandate. So in sum, those two elements force competition authorities to replace those ecosystem holders in designing the product and also balancing their governance scheme across their platforms, which is sometimes also undesirable from the perspective of antitrust. So these inconsistencies led the European Union passing the Digital Markets Act 3 years ago. And basically, the DMA mandates different types and degrees of interoperability upon the designated regulatory targets. We call them as gatekeepers, depending specifically on the type of services that they operate, and also the economic characteristics that the legislator pointed out as problematic in the regulation's impact assessment. So, aside from the provision that I will be dealing with in depth in a couple of minutes, that is Article 6.7 of the DMA, the regulation also compels gatekeepers to abide by the principle of openness by, on one side, imposing alternative app distribution or mobile ecosystems, and on the other, also mandating messaging services to interoperate horizontally. So, in the first set of cases, gatekeepers must implement Article 6.4 of the DMA to ensure that alternative app stores and side loading are possible for their competitors or their complementars in their mobile ecosystem. And unlike other provisions, which hold more of a categorical nature, Article 6.4 of the DMA also states that the gatekeeper can adopt measures to preserve the operating system's integrity and security in opening up these markets. And in a similar vein, Article 7 of the DMA mandates the operators of messaging services to enable end users to use competitor services indistinctly on their own interface. But also safeguards relating to encryption and also privacy may be introduced by the gatekeepers in the form of restrictions under the assumption that they are necessary, proportionate, and also sufficiently justified. Furthermore, and going back to Article 6.7, that particular provision mandates gatekeepers to provide, and this is really important, free of charge, effective interoperability to complementars to the gatekeepers' software and hardware features. They are available to the regulatory target's own services and hardware. That is to say, the provision of services and also information to third-party access seekers must be granted on the same terms and on the same conditions, within the same timescales, and using the same systems and processes, and also with the same degree of reliability and also performance as opposed to the access granted to internal access seekers. And abiding by this particular provision, if third parties cannot adequately integrate the features controlled by the gatekeeper into their own services, apps, or devices, then such an effort will not meet the threshold of effective interoperability. So, building and going to a particular example that has unfolded within the DMA's enforcement, building on this particular obligation on Article 6.7, Apple, I would say, is really the main target of the European Commission's enforcement actions. And in September 2024, the European Commission issued 2 specification proceedings to set out the implementation measures that this particular gatekeeper should comply with to abide by the effective enforcement threshold of Article 6.7 of the DMA. And the first specification proceedings touched upon Apple's procedural means in implementing the regulation. So on the slide, you'll see Apple's initial enforcement strategy of Article 6.7, which basically consisted on introducing a request-based process by which complementars could access really no information about the available features that they could seek access to, and even if they did have that information for one reason or another, Apple would remain completely detached from assuming any responsibility for providing interoperability. So after the European Commission's intervention, the request-based process that Apple had initially proposed turned much more complex, but also much more transparent, and also provides more guarantees to complementars in terms of the instances where, for instance, they can seek redress against Apple's decisions to refuse a particular request, or to do it under different conditions than those initially proposed by the gatekeeper. And the second specification proceedings tackled really the practical implications of Apple's request-based process, to the extent that they detailed what individual and specific features of the gatekeeper Apple must provide access to its complementers. So the European Commission really performed quite a detailed analysis of every single feature, and it set out in black and white the specific APIs, protocols, and also functionality that complementers should have access to as a default when they interact with Apple's mobile ecosystem. So by engaging in this double-tiered enforcement strategy, the European Commission really seeks to try to complete the different aspects of interoperability that emerge from the literature. And those would be the technical, the syntactic, the semantic, and the organizational aspects. So, in other words, the European Commission did not really conform with simply indicating the features that the gatekeeper must provide access to, because that would be really only cover the technical aspect of interoperability, but the regulator instead went on to explicitly highlight how those features worked at the backend perspective, through also analyzing its underlying infrastructure and also their underlying protocols. So complementers and also gatekeepers must not only in that sense talk the same language across their system, so that would be the syntactic aspect of interoperability, but they must also learn to understand each other and to try to reinforce the complementers also catered service in the market with the ultimate goal of reaching this threshold of effective interoperability. And additionally, the European Commission also adjusted not only to these technical aspects surrounding interoperability, but also to some high-level principles inspiring their real-life application. So, for instance, the enforcer also introduced the principles of transparency, fairness, and non-discrimination as guiding principles to the gatekeeper's treatment of access requests by third parties. And in particular, I would say that the success of really the DMX implementation hinges on whether this comprehensive enforcement strategy can generally open up mobile ecosystems, since Apple has really already voiced out its concern with the provisions application by declaring that it hinders its innovation efforts in the EU. And our collective focus now, I would say, therefore, must really turn to try to monitor its application, so the application of this vertical interoperability mandate, to ensure that these obligations translate into tangible contestability and fairness, enabling complementers to really innovate on truly leveled terms. And this transition, I would say, from the retrospective antitrust battles to proactive regulatory design really marks, I would say, a historic moment in governing the digital economy. And with that, I have also listed on the slide the research outputs resulting from this analysis of the European Commission's current enforcement actions relating to vertical interoperability. I'm really looking forward as well to the discussion, and thanks you for your attention.
Thank you very much, Alba. Very, very comprehensive and clear overview of what's happening in the European Union. I recommend reading those articles, to our audience, because they're very, very informative. And I would like to highlight what you mentioned, that transparency is also a big part of the picture. And this was clear in these proceedings against Apple. For instance, some of the transparency aspects were related to Apple making clear from the outset what features interoperability could be applied to. And also, the European Commission requested Apple now to have a process of dispute resolution and key performance indicators that could be available to everybody that would like to make their service interoperable with Apple, to know, how they're managing their interoperability requests. So I think this is why, transparency is also an important picture of this. And now, then I want to move to a jurisdiction where also transparency was an important goal from the outset. In Japan, I know that there was an act for digital platforms that very much focus on transparency, but now more recently they enacted specific legislation in relation to mobile ecosystems that also has some provisions regarding transparency, but also much more substantive obligations of non-discrimination and interoperability in a more technical sense. So I would welcome our colleague, Professor Kazuhiko Fujikawa. I hope I'm pronouncing the name correctly. To shed some light for us on the application of this act, and also a general introduction on this act and how interoperability is done in Japan. So thank you very much, Professor. You have the floor.
Thank you so much for your introduction, and it's my honor to be able to speak to you today. Yeah, I would like to introduce Japanese Anti-Monopoly Act and ex-ante regulations. So I would like to share my slides. So just a moment, please. Okay. Yes. I hope. Okay, just a moment. I will.
It's sharing. Okay, now we can see it.
Okay. It works. Okay. Yeah, I'd like to explain the Japanese Anti-Monopoly Act and the ex-ante regulations. And Japanese Anti-Monopoly Act was enacted in 1947 and introducing an American type antitrust framework. But
excuse me, maybe you want to put big screen slideshow.
Okay.
We are seeing also the notes.
Maybe just a moment. Okay, so just a moment. I think just a moment. Maybe this is better, I think. So is it better now?
Yes, it is better.
Okay, yeah. So Japanese Anti-Monopoly Act enacted in 1947, and basically originally it's a American type antitrust, but it's a administrative law, unlike U.S. antitrust law. So it fundamentally possesses the character of an administrative law. So country recent competition law enforcement has adopted the EU competition law style. So Japanese Anti-Monopoly Act can thus be described as a competition law combining characteristics of both American and EU models. So in this sense, it's a good, how can I say, example to, how can I say, think to think comparative study. We have smartphone software competition promotion act and transaction transparency act as ex-ante regulation. So in Japan, we have the ex-ante regulation and co-regulations. So Transaction Transparency Act as a co-regulation. So, however, it is limited to the smartphone software sector. So, Japanese legislative process is relatively strict. So, Japan tried to focus on the real facts in Japan, and so smartphone software in smartphone software industry, Apple, Google and Google are dominant. So JFTC focus on the smartphone software sectors. Then now we have a DMA type ex-ante act now. So, and in addition, Transaction Transparency Act, equivalent to the EU's P2B regulation. So, it's, I don't know, but in my understanding, the EU P2B regulation not so work well. So yeah, maybe please correct me. But in Japan, it serves as to clarify actual condition and initiative investigation, and it allows understanding of stakeholder opinion. So yeah, in Japan, Transparency Act serve as a kind of clarification of the actual condition in the digital sector, and it is helpful to initiate investigation. And so Anti-Monopoly Act as competition law, and Smartphone Software Competition Promotion Act is also regarded as a competition law. So it's a how can I say, a difference between EU's DMA and Japanese Mobile Software Act. So in my understanding, the EU's DMA is not a competition law, but it's a it's just a ex ante regulation, but it's not a competition law. So maybe there is a controversy, but in my understanding, so in Japan, at least, both Japanese Anti-Monopoly Act and Smartphone Software Act are both competition laws. And the Transaction Transparency Act as co-regulation, and it's not a competition law, but it's useful to identify the cases. So Act on it's a Mobile Software Act. So it's promotes a competition or between mobile ecosystems. So it allows open the app stores, third-party app stores, and competitors' browsers, and it also allow compete with how can I say operating system. In Japan, there's a concern about the deterioration of the level playing field in mobile ecosystems. So that's why the Act on Promotion of Competition for Specific Smartphone is enacted, and so Ajak mentioned about the outline of the Mobile Software Act, and JTC designates software service providers. Now, in 2025, JTC designate Apple and iTunes and Google LLC, and this December, Mobile Software Act will be implemented. So it will soon be enacted, but so not enacted, not implemented at this moment. Then so there is a prohibited prohibited conducts and comparison requirements, and specific software company designated providers are prohibited from engaging the several conducts, and designated provider shall not prevent third-party providers from offering their own application stores. So, for example, the present Epic Android version is available worldwide, including Japan. But the iOS version is not. It's expected to become available. Maybe this December, because of the Mobile Software Act is going to be implemented. And yeah, this Mobile Software Act admits the justifiable measures and measures necessary to achieve the objectives of security, privacy, use protection, etc. Can be taken as long as it is difficult to achieve the objectives through other less restrictive measures. So the EU Digital Market Act, likewise, does not prevent a gatekeeper from taking measures and applying setting to the extent strictly necessary and proportionate. But those actions are limited to the scope of what is strictly necessary and proportionate. And the scope for justification appear to be considerable narrower than under Japanese Mobile Software Act. And JTC, sorry. Okay.
If you could wrap up in a couple of minutes, that.
Okay. Yeah. Okay. Yeah. So yes, and it also regulates the preferential treatment. So yeah, it regulates the self-preferencing conduct. And this act, so surcharge will be imposed up to 20%, and but total revenue, but it's a Japanese total revenue. So yeah, it's how can I say, not so severe as EU's DMA. Okay, so I'd like to skip this slide. And this is a Google case, but so JTC issued a cease and desist order, and Google unjust restrict business activity requiring pre-installation and prime placement of Google Search and Chrome with a license of Google Play, and is also required to exclude rival search services as condition for sharing advertisement revenue. Yeah. So so if the Smartphone Software Competition Promotion Act had already been enforced, it appears that this Google case in Japan could have been subject to regulation under the law. And and the Transparency Act, it's a co-regulation, so it's a originally voluntary basis, but 2024, METI is governs the Transparency Act, and the METI identified the illegal acts and requested GFTC to take appropriate action. And so it's a buy box. So it's similar to the EU's Amazon buy box cases, and it also happened in Japan as well. So so I'd like to wrap up this the presentation. So Anti-Monopoly Act. So it's a, like I say, it's a kind of combine combining aspect of the US and EU and in Japan, so JLTC regulate Anti-Monopoly Act, ex post regulation, and it also use ex ante regulation, and now Mobile Software Act will be implemented in this December, and transparency regulation. It's a co-regulation, but it's useful for identify the cases and understanding the factual situation. So in Japan, we use an ex post approach and ex ante regulation as both Mobile Software Act and co-regulation, Transparency Act, co-regulation. Okay, so thank you for your attention. And so this is a Japanese situation. So I'd like to discuss with the other jurisdiction. Thanks so much.
Thank you very much, Professor Kazuhiko. It's very interesting to hear these developments and to see that in Japan you have cases that deal with issues that are also then addressed by proposed regulation. And presumably this regulation will help speed up the enforcement and achieve more effective and comprehensive remedies. And I think one interesting thing to note is that you have a number of exceptions that to the restrictions that can be imposed, and this is a bit different from the DMA framework. It's closer to the competition law framework, where you have a broader set of justification that you can propose. So I think this is an interesting aspect. But an other thing that I wanted to highlight is that in Brazil, we also have this parallel application potentially. It could be that you have an ex post enforcement case that deals with specifically the same issues that then are going to be regulated by an ex ante regulation. This is similar to what has happened also in the European Union. So with that, I wanted to give the opportunity also to our commissioner, Victor Fernandez, to talk a little bit about this interaction maybe between ex post and ex ante, and give us a perspective from Brazil, from the trenches, really. So thank you very much, Victor, for accepting the invitation, and you have the floor.
Thank you very much, Nicolo. I will also share some slides. Please confirm me if you can see them.
Not yet, but I can see that you are sharing. Okay, now we can see.
Okay. Okay. So first of all, thank you very much for having me here today. It's a great honor to be sharing this panel, especially with some professors and colleagues that I admire so much, like Professor Fiona Scott Morton, Alba, and Kazuhiko. And thank you very much, Nicolo, more especially because Nicolo is one of the leading competition law scholars in Brazil, that bridges these connections between the Brazilian competition law community and antitrust experts abroad. So congratulations, Nicolo, for your work. It's very, very important for the Brazilian community as a whole. And for today, I have prepared some very simple slides on this topic, and I would like to give you some perspectives from the experience that CADE has gathered over the last years in some cases. And after that, we are gonna touch upon the new bill and what are the prospects of this new legislation for ensuring equitable interoperability in digital markets in Brazil. First, we have already touched upon this. It's important to emphasize that equitable interoperability is much more than technical interoperability only. And Professor Morton and her colleagues argue in their groundbreaking paper that it might function as some sort of a super tool of digital platform governance, and thereby transforming ecosystems and markets from competition for the market to competition in the market, or maybe in ecosystems itself. And so there is pretty much the concept of equitable interoperability that was discussed earlier by some of the panelists of this panel. And when we look at the Brazilian experience, we can see that Brazilian has gathered a very interesting and considerable experience in designing appropriate remedies for mergers that eventually involve granting access to data, or maybe access to APIs for digital products. But I guess that in comparison to this merger experience, Brazil has a very, very little experience when it comes to abuse of dominance investigations. And actually, we have only 3 cases that would be that could be considered in this notion, which would be the Google AdWords case and the Bradesco Guiabos case, and more recently the Apple case that is still ongoing in Brazil, and I will explain a little more about that. And I have just self-promoted a paper I wrote some years ago, talking about more specifically the first 2 cases, and explaining what were the remedies that CADE has adopted in these investigations. But I will also cover those cases now. So the first case, and it's a very interesting case because the case was eventually solved by commitments in the US, and this case was not discussed at the EU level neither. So that was a case that has arisen back then, when the Google has these discussions about self-preferencing with competition law authorities, and in the US, Google has reached a settlement agreement with the DOJ and the FTC, I guess, in 2011, and then this case was eventually closed in the US. But in Brazil, this case has continued, and then in 2019, we have reached a decision in this case. In the Google AdWords case, we were discussing the fact that Google would be abusing of its dominance by imposing some technical restrictions on its advertising API that prevented software developers from offering multi-platform campaigns management tools. So imagine if you are an advertiser who runs campaigns both on Google and Bing, for instance, and third-party tools couldn't effectively manage it both platforms, because especially because Google licensing terms created some very high technical barriers. And Google has argued that this was very necessary to prevent what would be called the lowest common denominator problem, essentially claiming that full compatibility would degrade the quality of the management of advertising campaigns in Google platform. And in this case, CADE has eventually, the CADE's tribunal has eventually dismissed this case in 2011, especially because CADE has adopted a very conservative approach here when it comes to the essential facilities doctrine. So it was like CADE has tried to fit the indispensability test in this discussion, and then that eventually led to the conclusion that the access to Google AdWords API would not be rendered would not be considered an essential facility for 30 parties that manage campaign advertisers. So, and after that case, CAGI has went another investigation, which is the Guia Bolso case. And this case was eventually solved with commitments, and that is what would be the only case where CAGI has designed effective digital interoperability measures as a remedy for an abuse of dominance investigation so far. So in this case, Guia Bolso was an app. The developers have made an app which advises people in terms of decisions across investments and things like that. I guess that there is a very similar personal finance app abroad in the US, which is the Mint app. It might be very similar. And on the other hand, there was Bradesco, which is one of our largest banks in Brazil. It's pretty much an incumbent in the financial sector in Brazil. And then some consumers has started to allege that they could not use the Guia Bolso app, especially because Bradesco was making it technically difficult for its users, its consumers, to connect, to interoperate their accounts to Guia Bolso. So, for instance, Bradesco has back then implemented some sort of a double password verification that was conveniently did not work with third-party apps and things like that. But here where it gets interesting, CAGI eventually negotiated a settlement with the bank, with Bradesco, requiring Bradesco to develop proper APIs that would allow consumers to share their data with Guia Bolso while still maintaining some minimal security mechanisms through encrypted connections. And that case was very interesting because CAGI has, for the very first time, the experience of monitoring a remedy based on interoperability measures. And on top of that, CAGI, in Brazil, there was great advances in the open finance sector, which is a regulatory tool for providing interoperability across the financial sector in Brazil. And the open finance remedies, the open finance measures, which are being constructed by the Brazilian Central Bank over the last years, has pretty much addressed these concerns. And today we have this very interesting system of interoperability in the financial sector. And finally, we have the Apple case in Brazil, which is a very interesting case because I would say it pushes the edge of the Brazilian competition law framework across several levels. And the case is very different, it's slightly different from the cases that has been discussed in the US and of course in the EU under the DMA. But in the Brazilian Apple case, there are three main anti-competitive practices that are being examined. The first one is the prohibition of third-party digital goods distribution. So under the Brazilian terms of the anti-steering Apple clauses, Apple forbids developers of offering in their apps third-party products. And the case was brought before CAGI after a complaint filed by Mercado Libre, which is the largest retailer, online retailer in South America. And basically, the Mercado Libre was saying that especially through the App Store's review process, Apple was forbidding developers to announce some signatures and some subscriptions to the Mercado Libre servers that would grant access to streaming platforms such as Disney Plus and HBO Plus and things like that. I think that kind of conduct was not scrutinized in the EU, even in the Spotify case, if I'm right. Second, of course, CAGI has investigated the mandatory use of Apple payment system, Apple EAP, which is attached by 30% fee commission, which is pretty much the discussion that is being taken under the EU as well. And finally, CAGI has also addressed the anti-steering provisions through which Apple prohibited developers from informing users about alternative payment methods or including external links or link outs to cheaper purchasing options outside the apps. And this case was eventually ruled by CAGI this year. CAGI has adopted an interim measure against Apple. And those interim measures remedies are very, very interesting. I will talk a little bit about them. But more importantly, I think that that was the first case where CAGI has shown a greater openness to discuss ecosystem-based theories of harm. And we have the CAGI's decision available in English. I have put in this QR code here. And CAGI has put forward two main theories of harm. And I would say that the most relevant one here is the idea of a defensive leverage theory of harm, which was pretty much based on the Ziegler Commission report of 2011, of 2019, sorry. And CAGI has considered that all of those conducts taken together as a whole, the anti-steering provisions, the mandatory use of Apple payment systems, they were restrictions that would ultimately designed to prevent complementators from disintermediating the central platform or to create alternative distribution channels that could threaten Apple monopolistic position in the distribution of digital goods in iOS as a whole. And I guess that it's pretty much the core of the history that is being told in this Brazilian Apple case here, because when we look at this conduct in isolation, it might not be clear for people what is the whole strategy here. And we also have discussed some other offensive leverage theories of harm, like self-referencing, which is pretty much common in digital space. And on top of that, we have adopted a very interesting perspective of sign, because we have discussed that sign does not, under Brazilian competition law, and I would say that is very, very interesting. For trying to be anti-competitive, parts or CAGI does not have necessarily to show antitrust foreclosure in the traditional sense, because as we assess it in this case, when we look at the Apple Store and the App Store case, tying, especially tying with the mandatory use of Apple payment system, could be considered a strategy to intra-product discrimination. And that comes to some other studies that raise this perspective. But what seems to us is that this was a strategy to disproportionate extract value from a specific class of developers, which are developers relying on recurrent digital transitions. And that would be some sort of a metering strategy adopted by Apple. And in this tribunal's decision, the CAGI's tribunal has adopted three main remedies: the end of anti-steering provisions, the need of Apple to be open to alternative app stores, and Apple should segregate the App Store services and the use of Apple payment system. But nevertheless, that was an interim decision. Apple has contested this decision in the judiciary branch. And because of that, CAGI is discussing some commitments with Apple, and those commitments are very, very hard to sign. And I think that Professor Morton has said that it requires some imagination, and I would say that that's the most difficult part in designing this remedies. And last, we have the new Fair Competition Act for digital market, which is being discussed in the Congress right now. It was proposed by the Brazilian National Congress last month, and that's a groundbreaking legislation, I would say, for Brazil for several reasons. Just like Kazuko has mentioned about the Japanese experience and the Brazilian competition law framework from the 19th, it's pretty much influenced by the American antitrust legislation and the American experience. So the Brazilian competition law frameworks especially endorsed the consumer welfare standard model, I would say. And this new proposal is not a standalone legislation for Brazil, but it creates a new chapters inside of the Brazilian Competition Act. And in order to do that, the Fair Competition Act adds 3 new goals for the Brazilian competition law framework. And I think that's the most relevant part of the bill, because it says that Brazilian competition law is not anymore about efficiency focused trade-offs, but rather should look at 3 different goals, which are reducing barriers to entry, which pretty much resembles the contestability goal of the DMA, protecting competitive process, and also promoting a freedom of choice. Unfortunately, I can't explain why, and the bill does not mention any sort of a fairness-like goal in the legislation, and it's not clear so far whether or not this omission will have some impact. Those are some of the features of the bill, how the special obligations regime would operate. And I had the great pleasure to discuss a little bit about that with Alba and the binary Agora in a very interesting video. And finally, just to link with the topic of today, when we look at the obligations that are outlined in the Brazilian legislation, and those are a list of non-exhaustive obligations. Those obligations will be ultimately drafted in a customized way through some sort of commitments. But there are some obligations, especially prohibited conduct, that are prone to avoid difficulties in interoperability provisions. And so I think that those tools and those obligations could be pretty much used to grant interoperability in equitable terms, as we are discussing here. But I think that's all for now, and I appreciate your attention, and thank you very much for having me for this.
No, thank you, Commissioner Victor. That's perfect. I think it's particularly important that you mentioned the ecosystem approach. So the idea that is in the decision of the Apple case that highlights the dependency on digital platform, particularly mobile ecosystem, and the need to protect more than a specific market. So that's one important point. And the other one, I also want to draw the attention to that first ruling that you mentioned, the Google AdWords case, because that defense that was used saying that the lowest common denominator phenomenon happens if you make things interoperable. I think it's something that is generating controversy also nowadays, because it's about the scope of interoperability. Like if we define broad obligations of interoperability for everything, then the argument goes, there is no incentive to build differentiating features because everything needs to be made interoperable. So I want to make the use of this last segment to pose some questions. We also have 2 from the chat, and then you can all answer, also raise questions to your panelists if you want. So the first one would be about this. How do you see this argument about, what's the proper scope of interoperability because of this, to avoid this lowest common denominator idea? And perhaps something that is also useful here is to understand if the interoperability mandates need to be complemented with some policy of investment into building public infrastructures, because this is also something that came up in the Apple decision, that payments could be made interoperable with Brazil's digital public infrastructure, PIX, the instant payment that Brazil has. So when you have that, you have, I think, more effective winning solutions if you can combine the 2. The other thing that is also interesting to consider is the cost issue. So whether the cost for implementing interoperability should be imposed totally on the gatekeeper. So the DMAs does that, says that interoperability must be completely free. But on the other hand, you have those that say that it would be fair to remunerate, recover the basic cost of implementation of this. And this is what happens, for instance, in open banking here in Brazil, which has this ecosystem approach. So I think that's another interesting detail. And finally, related to the questions that we received, the questions are for basically everybody, and they're about considering that interoperability and transparency remedy can be designed through both ex-ante and ex-post regulation. How do you see the balance and coordination between these 2 approaches evolving the mobile ecosystems? And similar, the other question, how do you ensure, which mechanism you use to ensure that the ex-post approach ensures equitable interoperability in practice? So these 2 questions are basically about how you coordinate the ex-ante and ex-post. And I think some interesting ideas that were posed are maybe the ex-ante framework can specify and regulate more specifically the exceptions. There was also a reference to possible standardization on, for instance, how security is assessed, auditing over that could be imposed through ex-ante regulation. But also the suggestion that maybe the dialogue co-regulation is a way that you can implement some of these provisions, particularly in the Japanese context, this was mentioned. So overall, I think we are dealing with this issue, how to coordinate ex-ante and ex-post. And it would be very interesting to hear anything that you would like to complement what you already said. And I take the opportunity already to thank you for your valuable participation. Maybe we can go back to the original order, so starting with Professor Fiona and then everybody else.
Yeah, let me just briefly say something about differentiation and incentives. I think this is just a lazy excuse. It is not difficult to design interoperability such that you can keep the piece that generates network effects that everybody wants and allow differentiation on other things. My favorite example is if you text happy birthday to somebody these days, sometimes you get balloons and confetti and, special effects, and sometimes you don't. But I mean, it doesn't matter if you don't. If somebody is on another network, you're still telling them happy birthday. So a network that wants to have special features that apply only within itself because it's differentiating based on something is welcome to do that. And then everybody else is still getting the functionality that is giving us that entry, that single network effect. And obviously you have to have a technical committee that lets that standard evolve over time. If we were doing social media today, we would include video. If we were doing an interoperability standard for social media 15 years ago, we would not include video because bandwidth was too small and this was not a normal part of the user experience. So I think this is just the refuge of the non-creative people. This is completely solvable. On ex ante and ex post, I think ideally in an ex ante system, you're solving enough of the problems up front so that you get faster a resolution and you get less game playing because everybody knows what the rules are. But you do have to apply competition law to deal with behaviors that were not foreseen up front and try to evade the competition law. So they definitely are complements. You need both of them. And I would also advocate for something like a market study function of the regulator. So the regulator might worry that it's seeing some behavior it can't control with the ex ante regulation and want to carry out a market study and report to the Congress saying, look, or the competition authority, look, here's this behavior. We don't think it's in the public interest, but our tools do not let us address it directly. So somebody else needs to handle it or give us a new tool. And that kind of regular reporting and self-study, I think, is something that a sectoral regulator can do. I'll stop there.
Thank you. That's very much in line with what we are advocating here. Alba?
So thank you, Nicola, for all of the questions and also the audience's question. I was thinking about this argument that you touched upon, and also Victor also remarked on his presentation about this really race to the bottom that would emerge as a consequence of the introduction of interoperability. And I was also considering all of this narrative that gatekeepers have now come up with in terms of, okay, we are required to provide interoperability to some of our features. Now we are avoiding to innovate in some jurisdictions, although we see a clear pattern every time, in the sense that first they come up and say we are not doing that for instance, in the EU or in a particular jurisdiction which is regulated, and then I have seen that 6 to 10 months later they roll out those features in the EU or that particular jurisdiction. We have just seen that with Apple with regards to the live translation of its headsets. So I don't know whether those arguments really hold ground, although I am really worried about the fact of the introduction of these, for instance, the Brazilian bill, how it's going to interact not only with exposed Brazilian competition law, but also with other ex-ante regulations that really apply in other jurisdictions, because it's true that legal standards can become conflated in the sense that some jurisdictions have some legal standards for applying particular remedies into the market, whereas other jurisdictions will naturally apply and draw from their tradition, from their antitrust tradition, and say, this is a different legal standard. We want more proportionality, we want more transparency than the European Commission or the GFTC or the CADE now with its new regulation. So I was wondering how that will really piece together and really unfold in practice. And I see loads of coordination having to take place between competition authorities, not only with regards to the local impact of those regulations, but also internationally, because I predict that that's going to be like the real contentious issue, in the sense of gatekeepers really highlighting that they can't really comply with all regulations because it's just too much to have all of these regulations at the same time asking for different questions, although they do that for many fields of law already. On the side of the cost for implementing interoperability, I also believe that Professor Scott Martin talked about this a bit in her introduction, in the sense that we already had, and we were discussing, Nicolo, about this Android Auto case that we had in the EU. This case basically came from the Italian jurisdiction because an Italian provider for electric cars had an app for really checking where the posts and the chargers for its electric cars were located within Italy, and Google didn't provide interoperability or rejected its interoperability request to be integrated into what's called the Android Auto, so the desktop of the electric cars. And there we have like maybe the counter argument or the other side of the coin relating to this Google AdWords case that Victor brought about, in the sense that the Italian and the Court of Justice have really said that the essential facilities doctrine is not applicable, in the sense that the indispensability criterion is not to be demanded or met by the competition authority, but rather that we must assess degradations or denials of interoperability in a different light, especially when we are talking about open and closed ecosystems, and those consequences really are different if it's an open or a closed ecosystem. For instance, in this case, with Android's case, we saw that really the degradation of interoperability was really equated to an anti-competitive harm, because Google did not demonstrate that it wanted to close its ecosystem. So that's maybe kind of a conflicting or really a challenging idea to grapple with. And in parallel, also in Android Auto, the Court of Justice also recognized that gatekeepers or incumbent undertakings must be remunerated in some shape or form, and some commentators are already saying that particular remark from the Court of Justice can be translated and transposed to the DMA's application. So we might see that now gatekeepers advocate for some cost being relayed onto competitors. And finally, on the point of ex post and ex ante, it all really depends on how close or how inflexible the ex ante regulation is. Because, for instance, with the DMA, we have seen that it only captures certain types of services. So all services remaining outside of the scope of application of the DMA are really to be captured by antitrust. That's a real direct consequence of the DMA's application. And in any case, those concerns that do not really address either the objectives of contestability and fairness really would have to go through the antitrust pathway. So that's, I would say, my solution on how to keep this balance between ex post, ex ante, and also maybe the international dimension to it all.
Thank you for the comprehensive answer. Please, Professor Kazuhiko, you have the floor.
Thank you so much for questions from floor. And yeah, I'd like briefly to answer my comments. So yeah, so differentiation and innovation. So the innovation process is also important, and yeah, but we need to care about the network effect, and yeah, dominant tech giants try to, I gotta say, entrench so ecosystem and its yeah, market powers. So we need to how can I say, both we need to balance. But so in this aspect, I think that the market study or co-regulation is yeah, sometimes effective. So yeah, in Japanese case, according to the co-regulation, so transaction party, how can I say, reports the suspected acts. So JDC can detect the how can I say, the harmful conduct. So the party knows that the transaction party knows that the how can I say, real how can I say, harmful conduct, and yeah, even suspected conduct. So, and yeah, it's helpful to investigation as well. And how to coordinate ex ante and ex post approaches. So we in Japan experienced the Google case, and it's a JTC regulate the Google case as a preventative regulation. So it's just a cease and desist order. And in my opinion, the one of the reasons is it's difficult to how can I say define the market and how can I say prove the substantial harm to competition. So by using the ex ante regulation, we can skip the very, how can I say, difficult part of the proof. But at the same time, we need to care about the so over-regulation and choose innovation. So I think that the justification is also, how can I say, very important part. So now in Japan, JTC opened the advisory council and professors and many parties get together and discuss. So yeah, we need to think about justification. So and we need to it's a very difficult part to think about the remedies, and so maybe we need to talk about that. So yeah, I'm very impressed to many approach to interoperability. So in Japan, Mobile Software Act provides that only disclose the how can I say the information of the for example the change of the settings and the terms of contract as etc. But I learned that the EU specify that the technical how can I say API or something like that. So that's a Japanese challenging part. So yeah, thanks so much for your
Thanks to
question.
you. Just maybe to confirm our understanding, this mobile specific competition act was considered necessary because the Platform Transparency Act was insufficient to deal with some of the conducts.
Right. Yeah. So Transparency Act cover the not only so for example the I say the online market sector or something like that. So mobile the ex ante act only focus on the mobile sector. So yeah, Transparency Act cover the other sectors.
Okay, thank you very much. That's also an inspiration for us to look at, and you have very detailed guidelines on how to implement this Mobile Software Competition Act, which I think are very interesting to learn from. So let's come back home to Brazil and here, considering all we have heard, are you optimistic, Professor Victor? And you also might want to address some of the questions, but basically, how should we feel now about digital market regulation in Brazil?
Thank you very much, Nicolo. I would say that there is a great amount of hope in this new legislation that might be enacted or not by the National Congress. And parallel of that, I guess CAGI is also digging deeper in the antitrust investigations in digital markets and trying to reach some maturity, I would say, in assessing these cases. But when it comes to designing remedies for ensuring equitable interoperability, I would say that there is a very intense challenge in designing these remedies under an exposed regime, which is that, of course, CAGI and any other antitrust agency could design and impose remedies that will ensure interoperability. But the most difficult part, I would say, is that when you do not have an ex ante legislation in place, there are some limits, I would say, in what it concerns to legitimacy of the intervention. And when we look closer to the cases, just like the Apple case in the EU, we see that there are many ways of designing remedies for the preoccupations that were appointed in an antitrust investigation, and it's not clear whether the new business model that companies put in place to formally address those concerns will be eventually aligned with the goals, the normative goals of the ex-ante legislation. When we are under the ex-post regime, I would say that it would be quite easier for companies to design a new business model that would eventually circumvent the intended goals of the interoperability remedies, but they do that by alleging that the normative legislation in place does not cover broader objectives or broader goals in terms of fairness or in terms of contestability and things like that. And that's the point why many people in Brazil claim eventually that CADE would not need an ex-ante legislation, because the Brazilian competition law framework is indeed very modern in the sense that it grants CADE powers to adopt interim measures and things like that. But I guess that the debate about the goals of the legislation, normative goals of the legislation, roots legitimacy. And that's very important for a competition authority to work, especially when we are talking about complex remedies for digital markets.
Great, that's very important remark. And yes, we do hope that this bill will create a legitimate framework for more effective action in digital markets. With all that, I mean, I think we have a lot to think about. We have reached now 2 hours of discussion, so everybody has contributed a lot. Thanks a lot. We really appreciate it, and we'll make sure we share the video of this webinar that is available on YouTube with our colleagues, and looking forward to engage in more conversations with you in the future. So thank you very much.
You're welcome. Bye-bye.
Thank you very much.
Thank you.
Thank
Bye-bye.